A Supreme Court vacation bench of Justices Vineet Saran and B.R. Gawai today granted interim bail to YSR Congress leader and Member of Parliament Kandamudi Raghurama Krishnam Raju in the sedition case that was filed against him by the state of Andhra Pradesh. The Y.S. Jagan Mohan Reddy-led government of Andhra Pradesh had filed an FIR against Raju, stating that he had committed an offence under Section 124A, that is an offence of sedition, and Section 505 of the Indian Penal Code, that is defamation. The FIR was after the Member of Parliament made certain remarks and statements against the Y.S. Jagan Mohan Reddy-led government on social media and on certain news television channels. The Supreme Court had ordered Raju to be examined at the Army Hospital Secunderabad. The Army Hospital had submitted its report to the Supreme Court, where it stated that there was an undisplaced fracture in its second toe of the left foot and that he also had certain injuries on his body. Senior advocate Mukul Rohatgi, appearing for Raju, submitted that the report itself establishes that he suffered custodial torture. However, senior advocate Dushyant Dave, appearing for the state of Andhra Pradesh, submitted that the report details which was there on behalf of the Army Hospital, it was only general medical conditions and that it did not divulge whether the injuries were new or old. He further submitted that Raju was giving interviews while he was going to the Army Hospital Secunderabad and that he was showing his feet by the window pane to the press. However, the Supreme Court today in its order has noted that it is of the prima facie view that there is a possibility that Raju was indeed tortured in custody. And it is on this reason that the Supreme Court today enlarged Raju on bail. The Uttar Pradesh government today moved Supreme Court against the May 17 order of the Allahabad High Court, wherein a division bench in its suo motu PIL regarding COVID-19 issues in the state has given a number of directions which the state government should comply with so that the COVID-19 situation in the state is taken care of. The High Court had given directions like ambulances with ICUs should be made available in every villages. However, Solicitor General Tushar Mehta submitted that the Uttar Pradesh government cannot possibly fulfill all the directions, given that there are 97,000 villages in the state of Uttar Pradesh and that giving 2 ambulances with ICUs in every village was not possible. Solicitor General of India Tushar Mehta also made a request before the bench that all COVID-19 issues, when heard by High Courts, are only heard by the Chief Justice of those respective High Court-led benches. The Supreme Court today noted that indeed High Courts have been working a lot in these COVID-19 related issues regarding respective states. However, in the anxiety to do something better for the patients, they often pass directions which the state governments cannot implement. Hence, the court has asked that the High Courts, while passing orders, also keep in mind that the execution of the orders should be possible. However, the court has also noted that when there is a transnational issue or a national issue, the High Courts should not order anything because the Supreme Courts deal with it. Thus, the 2-judge bench of the Supreme Court, headed by Justice Vineet Saran, stayed the May 17 order of the Allahabad High Court and has asked the state government to consider the directions as mere observations. However, the proceedings in the suo motu case will now continue before the High Court. The court has declined to entertain the request of only the Chief Justice-led benches of High Courts to hear COVID-19 issues, and it said that it does not want to demoralize the High Courts and that the Chief Justices of the High Courts have the prerogative to set up benches and that it would not be interfering in that regard. The Supreme Court bench of Justices L. Nageshwara Rao and Ravindra Bhatt today upheld a government move to initiate proceedings under the Insolvency and Bankruptcy Code against personal guarantors, usually promoters of big business houses, to corporate debtors facing corporate insolvency resolution process. The 2-judge bench has today upheld the November 15, 2019 notification of the central government allowing creditors, usually financial institutions and banks, to move against personal guarantors under the IBC was legal and valid. The notification of November 15, 2019 invoking IBC against personal guarantors was challenged before several High Courts initially. The Supreme Court had transferred all these petitions from several High Courts to itself in October last year. Well, that's all from Supreme Court today. Do stay tuned with Supreme Court Today tomorrow as well. And don't forget to like and share barandbench.com.